Good day. Thank you and welcome to Land and Property Focus, a program which is to help us all learn, have a discussion, and be empowered when it comes to land and property issues in Ghana. Today, our topic is Leaseholds Explained. And I tell you why it is important that we cover this topic. Since 1992, the majority of our lands have been sold leasehold. And the Land Act of 2020 took the last chunk of freeholds that were capable of being sold out to the market as well. It is therefore very important that we cover this topic so that the average person understands what they get when they have a leasehold document in their hands. Is it that you have opportunities? Are you able to negotiate? Are you able to look at the document that has been given you by a professional and understand what is in there, what your rights are, what your obligations are? And so this program is to help us all learn, have a discussion, and interact in such a way that we would all become better for what it is. It is not meant to be to give you knowledge to become the professional, but it is going to be able to help you to actually get involved in the conversation and understand what documents which you no doubt would have either by yourselves or relations or friends. Please do share your links on Facebook with your contacts, and do also subscribe to our video on YouTube. Today, we have made available for those of you who are watching us and do not have accounts on Facebook or YouTube, a WhatsApp number so that you can still send us your questions. And that number is +233 5000 673. +233 5000 673. We will look forward to having your questions and they can come through the show or right up at the end so that we can all interact and actually unravel this particular landholding area of Ghana. Now, I would move on to discuss the law as is the custom of this show. And this particular law, which has been chosen, would actually also be relevant to the area which we are discussing today. So the Land Act 2020, Act 1039, does provide under Section 1 for interest in land. So you'd see here listed 6 interests. Now, of these 6 interests, this leasehold is what is underlined. You would most likely see, or you should see these as a hierarchy of interests. We've got the allodial title, the customary, the common law freehold, the customary law freehold, the usufructuary interest, before you have the leasehold and the customary tenancy that comes into place. So whatever land you buy in Ghana now would have to have come from one of these interests. Of course, the first 4 are the superior interest, which you would see in my subsequent slides. And then the last 2 are the inferior interests, so-called. And we will be discussing leaseholds today because that is more the more common interest that is available for sale at this moment. With me today to discuss this topic of leaseholds is Mr. Eric Koranteng. Mr. Koranteng is a valuation and estate surveyor as well as a lawyer, and is a managing partner in a law firm in Accra by name astute legal legends. I take it a point to get people who have knowledge in land and property, perhaps before becoming lawyers, because I think the expertise that they bring on board is different from the bog standard lawyer who hasn't actually got any experience in law. And so Mr. Sankranting here would help us to discuss our leasehold issues today. Welcome, Mr. Sankranting.
Thank you, Nana.
So I'm going to split the show. We've got some slides which we're going to talk through. I'm going to split them into two parts. The first part dealing with general matters, which I will discuss with you, and I think some of them will stick out to you, and some of you might not like some of them, but that is the law or that is the practice. And Mr. Sankranting and I would go through slides of the specific titles and topics in leaseholds, which you may have been aware of, and you may have questions about. So I would go on my, okay, so in terms of the general guide, one would ask the question, what are leaseholds? Simply put, leaseholds or a leasehold is an interest in something for a specific period of time. But for something to be classed as a leasehold, there are three primary elements that must be in place. One is exclusive possession, the other is duration, and the other is rent. Your exclusive possession pretty much covers the fact that you have control or you have occupation of what you have been leased. So if you don't have that, it may be that you have a license rather than a lease. Your duration must be certain. So if you have a lease, the duration must be from A to B, and the duration, if even it's not as clear as saying A to B, it must be capable of being established if it was being looked at. Then your rent also come in. So you must pay something. It mustn't be $10,000. It could even be a peppercorn. It can be as low as anything, but there must be some consideration passing. And that is one of the three elements of a lease. If you wanted to find out what made something a lease, then these are three elements that would actually show it up to be a lease. Now, as I spoke about previously in terms of the law and interest available in Ghana, there are the four interests which you can see in gray: the allodial title, the customary freehold, the common law freehold, and the usufructuary interest. Now, those are classed as superior interest. And then you have the leasehold and the tenancy in common as inferior interest, because they always derive from the four above. And so I move you on to the next slide, where I show a typical leasehold timeline. So the accountant, for instance, would say a leasehold is a wasting asset because it starts and it ends. Every year that goes out of your leasehold means that you're getting to the end and you have to hand it over. So if you look at the diagram, the owner in this case who owns a superior interest, that superior interest runs from today or whenever it started right up through to the end of time. And within that gap or along that timeline of superior interest, they have just taken out a block which they give you as a lease. So that superior interest in the case of Ghana is going to be your allodial title, your customary law freehold, your common law freehold, or your usufructuary interest. So that is taken out. So whoever holds that superior interest takes out that portion and gives the leaseholder a lease. If you're lucky enough for your lease to be extended, then that adds on. If your lease is not extended, then it ends there. But you see, as the arrow moves, it moves right up to what the lawyers call, or the surveyors call, the reversion. That reversion belongs to the owner. So essentially, when you have a leasehold, you should know that it's going to end at some point. We don't know when, depending on how your lease is drafted, but it would end at some point. And when it ends, everything goes back to the owner. There are types of leases, and you might not be using any of these. I guess the most common would be the fixed length lease, which starts from, say, the 1st of January 2020 to the 31st of December 2030. That's a fixed length lease. Equitable leases are leases that are perhaps not following, especially not written, or not following some legal structure. But when it comes to the court and the court looks at the circumstances of the lease and what is happening, they rule it to be an equitable lease. So it's a lease that will be taken as a lease, but it is not a lease in written form or following some sort of structure. Then we have concurrent leases, where sometimes some landlords would have two leases running. So you have a tenant who perhaps is not paying rent, and they would give another lease to another person who then pays the rent direct to the landlord and kind of eases out the second person. But it's a kind of a structure which is not something that the average person would be given. We have also the reversionary lease, which is, if you consider the previous slide that I showed and the fact that when the lease ends, it gets to the reversion. That portion of the reversion can be leased. So you can have a lease now for, say, 90 years, and your landlord would actually lease the time after the 90 years to somebody else, and that would be a reversionary lease. Now, we all get sold leases. So there are a lot of people who sell leases in Ghana now because of our current dispensation. Now, it is key for us to be aware that there are two ways in which leases can be sold or transferred if it is not being sold. And these provisions, the provisions either for an assignment or a sublease, are not in every lease. They are in some leases. So for an assignment, it means that person who is giving you the lease is actually selling the entire term. So they have a 60-year lease and they're selling you 60 years. If it's a sublease, then they have a 60-year lease and they're selling you, say, 50 years, which means when the 50 years end, they come back in. So they are still your landlord. Whereas in the assignment, your landlord is the original person that leased the land to whoever is leasing to you. And the last on these general points, and I think people ask these questions: what happens to my land when the lease comes to an end? I wouldn't go through the Latin word, but the expression, but essentially it's saying whatever is affixed to the soil belongs to the soil. So when your lease ends, whatever you built on that land reverts with the reversion to the original person who gave you the land. So just be aware of this. I know we're going to have a lot of questions when it comes to the time, but that is essentially the practice, where when the leases end, everything that you put on the land actually belongs to the landlord and you have to walk away. So I would move on now to what you will find in a lease, and this is where Mr. Koranteng would help me through. So, Mr. Koranteng, every lease has a part for parties, and I guess in the case of Ghana, the parties can be very different, and they all have different rules around them. So, can you talk us through the parties in a lease?
Okay, and thank you very much. Before I start off, I want to say that all lease agreements must be in writing, except those agreements whose duration are less than 3 years. And therefore, it suffices to say that the law recognizes oral agreements for those lease agreements that the duration is less than 3 years. We have essential requirements of a standard lease, and my task is to walk you through these requirements. And the first of it is the parties. So the parties, we have the giver of leasehold interest, and they are popularly called the lessors or the sublessors. And then those who receive the leasehold interest are the lessees or sublessees. So if you are taking an leasehold interest from S2, then you have to know that you need to comply with Article 2673 of 1922 Constitution, which says that for S2 or a scheme to give a lease or to give an interest in a property, then it must be granted by the chief, including the principal elders of the S2 or scheme, and then a concurrence from the Lands Commission. If you are taking a leasehold interest from a family, you have to make sure that the head of family, together with the principal elders of the family, will give you that grant of lease to be sure that you are taking a valid lease. For when it comes to an individual, so far as the person is a rightful owner, can give you a lease. When it comes to company, with company, you need to comply with the requirements that are enshrined in Companies Act 2019. So you just have to make sure that the names, addresses, and then those who are rightful owners to give you the lease. So you have to do your due diligence to be sure that those who are giving you the lease are supposed to give you the lease. So that's would
Okay.
take care of the parties.
So I guess the difficulty for people who are watching would be if I meet Nana Kweku Mensah of Achimansa, how do I know who he has to consult with? Or if I meet somebody, Kweku Mensah, who says he's the head of, Abrazi family of Winneba, how do I know who I have to, who has to sign these documents? I think this is where sometimes our problems come in. So you go and see an individual, they purport to represent a family or a stool, and then subsequently somebody else pops up to say, well, I am also supposed to be a signatory and I didn't sign. How do we go past that?
Very well, and I think that it all boils down to due diligence, and therefore you need to engage, professionals to make sure that you are signing an agreement with the rightful owners. That is all about due diligence. Just make sure that the proper search is done to be sure that those who are giving you the lease are the rightful owners to give you as such.
Okay, I don't take that this is an advert for professionals, but anyway, we'll move on to the next slide. So there's also the concept of co-ownership in leases, and I don't think we do understand or appreciate it enough in our documents, especially when two or more people are actually acquiring property. Can you talk us through that?
Okay, and I think I left off with the giver of the leasehold interest. So when you want to talk about the co-ownership, the lessees, and that is those who receive the leasehold interest, and it could be an individual who gets a leasehold interest from those lessors or sublessors, as I've already mentioned, and you could also have more than one person being the lessees or sublessees who are taking an interest from the lessor. So either they will be joint tenants or they will be tenants in common. With joint tenancy, it means that there is a right of survivorship, and that simply means that the interest that the lessees hold cannot be divided or cannot be separated. And therefore, if one of the lessees passes on, then the entire interest devolves to the surviving lessee. When it comes to the tenants in common, there the interest is divisible and it can actually be transferred. So if there are two lessees, so one of the lessees can decide to transfer his or her interest, or when the lessee one of the lessees dies, then his or her share can devolve to his or her estate. So it is divisible, with tenants in common. But I must say that in Ghana here, there's a presumption that if there is no express intention to hold an interest as joint tenants, then the parties involved hold this as tenants in common. It means that their interests are divisible and they can share or transfer, as they want.
Okay. So I guess the take-home point is that because there is a presumption, you must make sure that you put it in your agreement if you do not actually want to follow that presumption. So if you're a married couple and when you die, you want your wife or your husband to take the property, then you should have joint tenants in there, in the agreement. But if you think that you're going to be tenants in common, which means when one person passes, the other can take the interest, then perhaps because the law provides for it, you don't need to put it in. But I think the general education point is for people to be aware that these things are there and to be able to influence their decisions or their documents based on these. Okay, so I'll go on to the
Yeah, but,
next.
but I think maybe I may have to add one more thing. You know, in
Yeah.
the Land Act 2020, there is a presumption that, for instance, spouses, if a property is transferred into a partner, one of them, like let's say if it's transferred into the wife's name, the wife holds that property as a trustee or hold it in trust as far as the other her husband is concerned. So even though we have this, there are provisions in the Land Act that also says otherwise. So with regards to spouses, actually.
Okay, all right then. So we go on to the background and the recital. I think a lot of our leases, I have seen leases where it tells you pretty much where the interest has come from. Sorry, if for instance somebody has died and it's been passed on, then it shows how whoever is selling to you has traced their. How important is this part of a lease?
Nana, this is very important. In fact, it's a very integral part of a standard lease. Now, recitals, specify the purpose of the instruments, and that is that we call uh, introductory recitals. So it specifies the purpose of the instrument. For instance, that a lessor has agreed with a lessee to transfer to the lessee at a consideration. So that is a introductory recital. And we have the narrative recitals, and that is where it gives the convincing historical events and instruments, that have transpired or occurred on the property over time. And that is where we have the root of title. So you should be able to trace the root of title, for some time. For instance, a good lease should have root of title tracing back as 30 years and then over. And if it is less than 30 years, doesn't mean it's not a good lease. But I mean, this is an ideal situation. That an ideal situation, you should have a lease which the root of title can date back as far as 30 years. So these are very, very important as far as the leasehold interest, the legal the leasehold agreement is concerned. Let me give you an example. In fact, this is the actual situation that we encountered in our office. A client walks into our office and holding an executed a deed of lease. And what he told us was that he had done everything, and he went to Lands Commission to register same, but it did not go through. So upon taking the deed of lease, we conducted a search at Lands Commission and realized that our client's grantor had not registered his interest at Lands Commission, and therefore there was no records of our client's grantor at Lands Commission, but rather our client's grantor's grantor details were at Lands Commission. So we needed to redraft the deed of lease, and I missed inconsistencies in the deed of lease, and that actually made us to understand that it was not drafted by a lawyer. So we needed to redraft the whole thing. So these are some of the important things as far as recitals are concerned in a lease agreement.
Okay, so essentially, the recitals should it should capture the nature of the agreement. It should also ideally capture how the person selling the land has actually come by that land. If they
Right.
came by settlement, or it's because somebody sold it to them, or they themselves had a lease. All those things must be covered in that part. Okay, so I'll move on to the next slide, which is about the duration of a lease. And I'll start with a question. there's a common notion that leases should be specific number of years. I have done my searches and never found anything specifically that speaks to a number of years for leases. Is there anything like that? Because there is evidence of years and leases running for 50 years with some rights of renewal. And then there is other evidence for 999-year leases. So is there anything on our statute books that restricts the term or the duration of a lease?
Okay, Nana, with regards to non-Ghanaians, I think the Constitution, Article 266 of the Constitution, specifies the duration within which a non-Ghanaian can acquire a leasehold interest in Ghana, and that is up to 50 years. But when it comes to a Ghanaian or a citizen, I haven't seen any cap on the years as far as the leasehold interest is concerned. But I think it has become more of a convention that you see people giving 99 years. But for non-Ghanaians, it is clearly stated in the Constitution that they can take up to 50 years.
Okay. So there's this issue as well where currently a lot of leases are being offered with the right to extend for further years of term. And I think for you and I as valuers, it is also a point where we have to advise people. If you're valuing property, even if the property has a break clause, so you have a lease with a break clause, you can only value up to the break clause because technically the lease may not continue from then. So in terms of value, any number of years that is given beyond the initial term doesn't really count. And I guess we may have to do a show specifically to address that matter, because I don't see that as, say, for instance, the example in the slide, 99 years plus 45 years, essentially is a 99-year lease, because you would only know what will happen after 99 years when you and the landlord have agreed as to, an extension. So you shouldn't consider it as a 144-year lease, because it's not. It is a 99-year lease. And then when you come to that point, you take things off from there. But I think what you have said and the point to take for people to take is we must make sure that we note what the start and end dates of our leases are. And those are very critical. As you can see, the duration itself is one of the critical elements of a lease. And therefore, we must know. And I think there's a point as well about the dates. Some leases refer to the dates of the agreement as a commencement date, whereas some leases actually state the date of a commencement in the document itself. So people would have to be aware of these and make sure that they actually know without being confused. The lease will say this lease dated 13 January. That may not be the start date. The date itself might be in the body of the lease. So people should be aware of that. Okay,
yes.
I'll move on to...
Let me speak to the duration. In the lease agreements, that the duration must be certain, as you initially indicated, and if it should commence at a certain point and end at a certain point. So, or if it is not, if it is not certain, it must be capable of being ascertained. The duration must be capable of being ascertained. And so if it is not capable of being ascertained, then it does not qualify to be a lease. And that was actually espoused in the case of a lease and Shankler, where they intended to tag the duration of the lease to the point when the war was going to end. But the court said that could not qualify as a lease because the certainty or the duration of it could not be ascertained, because there was no way they could ascertain when the war was going to end.
Okay, so nobody should accept a lease which says the lease ends when you become a rich man or a rich woman, because then we don't know when that would happen. That is essentially what you're saying.
Come again.
Okay, I'll move on to the next slide.
I didn't get you all.
Yeah. Okay. So the every lease has provisions for covenants. which is essentially the obligations that the tenant has. And then there are different classifications of these covenants. Can you please talk us through them?
Right. Thank you. Before I start talking about the covenant, let me define it. It's simply a promise by one party to the other with the intention to be bound by that promise. So we have categories of covenant. We have the express, the implied, and then the usual. For express covenant, the parties to an agreement, to a lease agreement, are at liberty to agree and insert any covenant they so wish to put in the lease agreement, so far as that covenant is not illegal or offends public policy. They are free to put that in the lease agreement. When it comes to the implied covenant, there are two legs. We have implied covenants under common law and the implied covenants under statutes. When you talk of implied covenant under common law, let me cite an example. It's one of it is, for instance, the lessor does not have to derogate on the grant that he has given to the lessee. For instance, if a lessor gives a lessee a property and the lessee immediately occupies that property, and the next morning the lessee wakes up to see the landlord or the lessor constructing a wall just immediately behind his window, to the extent that it blocks the air and light into the room. Okay, and does not, in fact, disregarding the allowable distance that wall between walls that's supposed to have. That is a derogation of grant by the lessor to the lessee. And also, when it comes to like the lessee undertakes to pay bills, utility bills, either electricity bills, water bills. It is an implied covenant under common law that the lessee is supposed to do. When it comes to implied covenant under statute, that is clearly stipulated in the Land Act, section 50 and 51 of the Land Act 2020. And one of it is, for instance, the lessor undertakes to ensure that the lessee enjoys it takes quiet enjoyment of the property. So, for instance, the lessor will not come up, one day will not get up because he has a personal issue with the lessee, will go and cut water and electricity supply to the property. That means that the lessee is not getting a quiet enjoyment of the property. And the lessee also, has an obligation to pay rent, and that is also under one of the covenants under a statute. Covenants implied by statute. When it comes to the usual covenant, these are covenants that are implied into agreement for a lease. Because for before you actually execute the actual lease, you may have a preliminary agreement, that is agreement for a lease, and that is where you have implied covenants regulating that agreement for a lease. And also, they say this usual covenants also are implied into oral agreement. I've already indicated that a lease agreement that the duration is below 3 years. They are not in writing, and therefore usual covenants are also implied into these oral agreements. And so you can have all these covenants under usual are useful adjuncts to the covenant implied under common law and that of under statute.
Okay, so I think the most important thing I've heard with these covenants, and I think what people watching us to take home, is the fact that under express covenants, you can pretty much agree anything. I have heard from many people where they're pretty much scared to even negotiate for longer terms. Now, when you go to somebody who is offering you a lease and they insist that they're only giving you 50 years, you are the one paying. You can insist that I would only pay if you give me a 100-year lease. And there's no law that binds you. I think we are not bargaining enough. We are only accepting documents, and because of that, the people who are offering these lands are actually just, taking us for a song and dance. You have the right to negotiate, unless the person giving you that interest perhaps hasn't got. If somebody just has 60 years, of course, they can't give you 100 years. But if that person has the ability to give you more, negotiate and get more. Don't be sold short by saying, oh, well, this is how they sell. You are the one with the money, and you have to make sure that you bargain enough for whatever is suitable for you. Okay, so I'll move on to the next slide, which is about rent. So can you talk us through rent?
Okay. So Nana, as we've already discussed, there are three, aspects of a lease. So the acid test for existence of a lease are that there must be rent, there must be exclusive possession, and there must be duration, as we've already indicated. So rent is one of the cardinal elements that making a lease. So for a lease, for the rent, you could have where a lump sum is paid as premium, and that is an inducement to pay rent in where the amount is below the open market rental value. So you pay a premium, a lump sum premium, and then you pay something nominal to the lessor or the landlord. And then you also have rent payment dates, and that is extremely important, because if you miss a rent payment date, it amounts to breach of the agreement, and that could also trigger abrogation of the contract. And therefore, it is something that you need to be extra vigilant and then alert on, to make sure that you don't miss rent payment dates, because we have penalties that could and that penalty could be even abrogation of the contract. And therefore, you could have an escalation clause in the lease agreement. So you have rent renewals, a mechanism, a rent review mechanism, where the rent will be reviewed upwards, periodically. So that is rent, as far as the lease agreement is concerned.
So in terms of take-home points, we must be aware of the rent payment dates, and make sure that we, I guess we have to also find out who we are paying it to and how we are paying it. And because there are practices that we pay a lump sum upfront, sometimes your rent is so low and you think, oh, well, it doesn't matter, they won't come chasing me. But I think you must make it a point to make sure that you pay, because that may cost you down the line. And if there's a rent review provision in your lease, as Mr. Koranteng has said, you must be aware of the rent review mechanism and how that is going to work. So we move on to permitted use. I think this is a subject that is linked into planning as well, but planning doesn't work that well. So I guess we will just look at the face value of a lease agreement, and if it has a permitted use, or it actually prescribes what it can be used for. Can you please talk us through?
Right. So this permitted use are part of the covenants that you find in a lease agreement. What I would say, for instance, if you take a lease agreement and the use of it is agriculture, you cannot change the use to residential, and that will amount to a breach. And because, for instance, even if a lease for agriculture would definitely, the value or what you would have paid as consideration will be something so low as compared to a residential lease, or lease that you have taken for residential use. And also, even aside that, the area would have been zoned as agriculture, so you cannot change the use without recourse to authorities that are vested with the zoning, restrictions and all that. And when you don't have approval, you cannot even go there to change the use. So that if you do change the use, it amounts to a breach. And also, so if you don't have, so what it says that don't buy land with use that you don't want. So if you know that it is residential use you want to put the land to, look for a residential look for a lease agreement that you have the permission to use as residential. If you want to use it for commercial, you need to look for a lease that the use is commercial. If you don't do that, that will amount to breach of the agreement.
I guess sometimes the problem that we have in Ghana is that people buy these lands as residential lands when they're in the middle of nowhere. And then when the town, develops and meets up those areas, some people are lucky enough to find their properties right by the roadside. And then overnight, they become commercial properties with stores and all that. I think the general advice is for them to go to the landlords and make sure that if the landlords know what they're doing, and they come to your land and it is given to you as residential and you've built a shop or something on it, they have a right to either abrogate the lease depending on how the lease was drafted. So it's a very critical point that people should be aware of. Okay, we go on to dispute resolution. So most leases have provisions for dispute resolution. And so can you quickly take us through what the best advice is if somebody was given the opportunity to make an input into how they should solve their dispute if it came to that? What would you say they should go for?
Right. Nana, I would say that when it comes to dispute resolution, the first cause should be ADR, alternate dispute resolution, because if you want to go to court, it can take a long while, and you and I know the litany of cases that we have, land cases that we have in the court, some spanning as far as 10, 20 years and are still in court. And then, for instance, if you have taken a lease agreement for a business purpose and for which you want to make sure that you don't want to disclose your trade secrets, then the ADR is the best option for you, because if you go to court, there will be a public hearing. But if you resort to ADR, alternative dispute resolution, that means that your trade secrets will be protected, and also the likelihood of getting resolution of whatever dispute is apt. And you can have that done within the shortest possible time. But if you want to go to court, it can take a while.
Okay, so essentially, those watching should have that in mind in terms of the difficulties there are going to court, and then taking a more, I guess, less formal and structured and perhaps even less costly approach by using ADR, which is, to be fair, replete in the Land Act 2020 as a mode of settling disputes. So we go on to renewal, which is also one of the very serious questions or big concerns of people in having leases as to what happens. And I guess, as I showed earlier on, the superior interest is running. So how are these renewals actually done?
Okay, so when I was talking about the covenant, we have the express and the implied. So in the renewals, you can have express and an implied, and especially with the Land Act 2020, it says that if you are giving a leasehold to a non-Ghanaian, a foreigner, then unless there's an express intention or it's expressly stated that that lease should be renewed after its expiration. If that is expressly stated, then it can be renewed. But where it does not state so, then that lease can never be renewed upon its expiration. But when it comes to bare land, when a bare land is being leased to a Ghanaian, there is an implied covenant that even if it is not expressly stated that such a lease will be renewed upon its expiration, it is implied that it will be renewed after its expiration. And also there's also where it has to do with the native of a community. It is where a lease is bare land is given to a native, then that needs and where it is even there's no express intention or it is not expressly stated that that lease will be renewed, it is subject to automatic renewal. So these are some of the implied and expressed covenant regarding renewal that you need to be careful of.
Okay. So essentially, there are provisions for renewal, but I guess it's on a case-by-case basis, and we would have to seek advice. Or if anybody has that question, we'll have to seek advice on the specific cases. So we go on to schedule, which we can perhaps. It always intrigues me that when you're going to buy land, I think the first thing you see is your site plan, and then the site plan gets done, and before you realize, somebody, most likely the land surveyor, comes up with a lease, and you can see a correlation between the site plan and the kind of the last few pages of the lease document. How important is this? And I think the take home point is about how people can look at the two documents and make sure that they make sense somehow.
Yes, then as you already indicated, this is extremely important because at the end of the day, you should have a site plan that relates to the property you actually acquired. So you have to make sure that the coordinates in the schedule correspond accurately with the site plan, with the coordinates on the site plan. I've seen a situation where a site plan, which was attached to a leasehold agreement, the coordinates were when the coordinates were superimposed on the map at the plan at Lands Commission, the coordinates were actually in the sea, were pointing to the sea. So it is extremely important that if you don't even know the know-how, at least get that's why you need somebody who has the eye to be sure that the coordinates in the schedule as described correspond accurately with those on the site plan.
On the site plan, okay. Thank you very much. So we go into capacity, which is more of those where the signatories and everything come in.
Right. So the capacity, I think the first slide talked about parties, and so there's a direct link to the capacities when it comes to the signatory portion. So as already indicated, if you are taking a lease from a stool or a skin, then you need to make sure that those who append the signatures are the chief, the principal elders of the stool. If you are taking from a family, you need to be sure that the one who is signing is the head of family together with the principal elders of the family. If it's taken from an individual, you have to be sure that the one who is giving you has the right to do so. And if it is company, then you need to make sure that you comply, that whoever is signing are those who the law specifies as those who have to sign for such agreement. And where you have a signatory who cannot read, it is incumbent on you to make sure that the document, the content of the document is read and well understood by the signatory, so that you provide a jurat, so that you will not have a problem for the person to say that it was not read to his understanding before appending a signature to it. And then you have the witnesses. So the witnesses will witness the various signatures that have been signed as those who constitute the parties to the agreement.
Okay. So we go next on to, because a lot of what we have discussed actually relates to bare land, leasehold for bare land. When, for instance, somebody buys property which is already built, there are other, and we would have a different show on that, which would cover the specific interest. But are you aware of these, and how important are these in those class of lease documents?
Yes. So basically, what we have dealt with the slides are most likely to be land, bare land. But when it comes to a property where the land has a building on it, then there are further covenants that you are likely to meet in a lease agreement. And these are the covenant to repair, decoration, the insurance. For instance, if you if there is insurance, you need to show the content of the property. Let's see, we'll make sure that we ensure the content of the property, whilst the lessor will ensure the building, natural building. And then we have alterations, governing alterations, and service charge rates, tax and utilities. These are all additional if it has to be a property that you're moving as a lessee.
Okay. So thank you very much. I think we've gone through these, and I will just summarize on the basic take-home points that we should all have, beside what I have already commented on. So for you to have a good lease, there are 6 points that you must look out for. One is that there must be a landlord who is able to give the lease. And we've gone through those who qualify and the classes of people who qualify. So you must see them as a block, and they must have the right to give you the lease. There must also be a tenant who is able to take the lease, and that is you. But it could also be a child, and because it's a child, they are not able to take a lease. So there must be a tenant who is able to take the lease that is given. Then we have talked about the length. The length of the lease should be clear. You may be ambiguous, but if it is ambiguous, it has to be capable of being ascertained. Otherwise, it is not a lease. Then the other point is that the land or property should be capable of being leased. It is not every property that is capable of being leased. So for instance, if you go into a town and they've got a sacred grove where they do their cultural practices, somebody might offer it to you. But if you do your due diligence, you'd realize that it's not actually land that is available to be sold, because it's essentially community land and not something that an individual or a group of people can sell to you. So the land or property should be capable of being leased. Then you should also say all the requirements of any law affecting leases must be followed. And that perhaps falls more to our lawyers and to our professionals who would guide you as to the relevant laws and these being enforced or being brought into the lease, or you being advised about them. Then the landlord must express intention to lease, and the tenant must accept the property being leased. This is more a function of offer and acceptance, that the landlord must offer and you must accept. And the offer and the acceptance must be mirror images of each other. There should be no ambiguity. I'm selling you land A, I'm buying land B. So that should be seen in your leasehold agreement. So essentially, that is leaseholds as we have discussed today. Thank you very much for following us through to this point. As I said, you can send us your questions through Facebook or YouTube. And then you can also send us a WhatsApp message through +233 500 600 73. And in coming to the questions, I think I had a first WhatsApp question that was sent to me. And the question was, it's quite a long one. Says, currently, land-related issues are the biggest facing the legal fraternity of Ghana and the government of Ghana in particular. Quite unfortunately, because it is predominantly seasonal, most certified legal practitioners avoid this vital aspect of the law in their dealings without giving the best professional attention in practical sense. The result is the numerous land-related issues in the country, especially in Accra, Greater Accra in general, and most other parts of the country, mostly mining areas. But in all this, Greater Accra alone has about half of the entire population of practicing lawyers. So what does this tell you? Well, I guess it's more a comment than a question. But I guess it speaks also to the general issues that we have with land litigation and the fact that perhaps our professionals, some of our professionals are not doing a good service to our land and property sector. I will go on to the first question, which is from Vera Jevemis. You say, are you able to share your slides, please? Yes, certainly. After the show, if you do send me your email address, either through WhatsApp or through email, I would send you the slides. And then we have, I'm just trying to, okay. So thanks for the show, Papa Toro. And then we have Princella Abeka says, it is not clear, please. Unfortunately, I guess we missed that part. But if there's anything we can do, Princella Abeka, please do ask your question and we would explain or give you answers as best as we can. Jay Kwashi, thanks for the free education. Peter Kinofori says, I need this one. Gershon Kurt showing some fire signs. Miokai Ayi, Mr. Koranteng is nailing it, and I'm loving it. We have a Dinkra photography, which says, wow, this is very vital information. Thanks. And then Juliet Pedersen Ayi say, Eric is a genius. Mr. Koranteng, it looks like you have a lot of fans out there today. Perpetua Asmeni says, great discussion. And Vera Jivemise says, great subject. I have Kingsley Amprechum who's saying, if one buys land and gets allocation forms from traditional ruler from Assam, which happens to my native village anyway, without any further document, what would be the status of the land in terms of lease or freehold? I think maybe I'll deal with this. It's a particular function of landholding in the Ashanti region where I am aware that people just have an allocation certificate from the rulers, and because nobody really challenges it, it is accepted as good. But if we have to be truthful and if we have to think of the future, then we have to start forcing the chiefs in the Ashanti region to actually go further than just giving the allocation sheets. I know this happens in Mampong as well, and this happens in Kumasi and like areas, but it is good because nobody challenges it. Once it gets allocated and you have a receipt or allocation sheet, but if you're a native of the town, then the Land Act, if even they gave you a leasehold and you're a native of the town, like myself, in the case of Assam, then I pretty much have a right of usufruct. So my lease would almost renew and continue renewing. But if you're not a native, then obviously different rules do apply. But it would be helpful that we actually move from this allocation paper thing, because sometimes you want to pass it on, and even though an allocation paper might do, it is good that we actually document these things and do it the proper way. Mr. Koranteng, do you have anything to add?
No, I have no useful thing to add to what you have already said. I think you've done.
All right. So thank you. We have a Vera Jivemis. I struggle to pronounce this name, but we'll get there. Can the contents in a lease be negotiated besides the duration of the lease? Yes, Mr. Koranteng, do you want to?
Yes, you can, and also depends on your negotiation skills and then, as I've already indicated, if there are covenants that are implied by law, and those ones that are implied by law, you cannot do anything about it. But those with that you can expressly agree between the parties, you can so do. So far as it is not illegal and does not offend public policy, you can agree on all those terms.
Okay, so Vera, there you are. It's a lease between you and another person or a group of people, and you can agree anything so long as it's not against the law. Kingsley Amprechum again. So what if a property is leased jointly to a Ghanaian and a foreigner? What period would be applied? I think that is under the Land Act. I guess it would be advisable not to do that, because there are two different classes of what a Ghanaian can get and then what a foreigner can get. Perhaps if both of you form a company and the Ghanaian has more than 60% interest, I think, in the company, then that company, being a Ghanaian company, can buy the property. But I would personally not advise a Ghanaian and a non-Ghanaian buying land together, because it will be difficult. It has to be one party with one interest and one ability actually being a party to that agreement. I don't know what you have to say, Mr.
Yeah, I think the Land Act makes with the company, if it is the foreign, if the foreigner has more than 40%, it means that then it is not a citizen. I think that's what the Act says. Yes.
Okay. So Ms. Amprechum again is asking the question: at the expiration of a lease, who has the right of renewal? I think this speaks to just what the lease provides for. And that is why we say you should, Mr. Sankrantin said that you should negotiate what you want. Your lease may provide that at the end of the lease, both of you would agree to renew. It may also provide that at the end of the lease, you must serve a notice to renew, or it may provide that at the end of the lease, the landlord should serve notice on you showing his intention to renew. And sometimes, as Mr. Sankrantin has said, the law implies the right to renew into the lease. And therefore, it doesn't matter what you or the landlord does. The lease can be renewed if you follow what the law provides for. So Vera again says, can you kindly clarify the process of due diligence to verify that we are dealing with a rightful party for the transaction of land or property? What happens and who does what? This is to manage my expectations that the professional that I've engaged has actually provided the expected service. So Sankrantin, this is firmly in your court.
So that's why I indicated that you need the services of a professional who knows what he has to do, to be sure that you are not getting the property or getting a lease from somebody who does not have the right to give you such a lease. So if you get the services of a professional, you are sure of getting, value for money.
Let me play the devil's advocate here, Mr. Sankrantin. Now, the professional hasn't got a book in his office that lists everybody who owns land, or the family members of every family that owns land, or perhaps if you're looking for the substantive chief of a bureau, maybe you go to a regional lands a house of chiefs, and it will tell you who is the chief of a bureau. But beyond that chief who is listed in that book at regional house of chiefs, how would even the professional get to know that Kweku Mensah is also a linguist, and according to customs in a bureau, Kweku Mensah is one of the people who must sign? I think that is where the question is going.
Nana, what is cited is one scenario. There are quite a number of it, but what I'm trying to say is that if you engage the services of a professional, the professional will go to that extent of making sure that all those who matter as far as the land is concerned, are giving giving the attention to make sure that you get the right persons to transfer the lease to you. A leasehold interest to you.
Okay, so Vera, I think if I can get Mr. Sankrantin well, go through a professional and blame him if he goes pear-shaped. So that is what he's saying. If go through a professional, he will do the due diligence for you. And if he goes pear-shaped, I guess you can blame the professional for that. Judith Sampson is saying, thanks for this. Kingsley Amprechum is saying, is it right for a lessee to evacuate any structure on the land at the expiration of the lease? That is as if that is, if I have a structure, can I dismantle it and move any movable parts away? Well, Mr. Amprechum, it's a very interesting aspect of, I guess it comes to Mr. Sankrantin with that later on, but he speaks to whether what you've put on there is a fixture or is a fitting. And if it's a fixture, then it is annexed to the land. If it's a fitting, then you can move it. So when you're moving out of your house, you may be able to take your TV with you, which you'd put on the wall. You may be able to take your sofas with you. But if you have dug a borehole, you can't say you're blocking it. Or if you've planted coconut, you can't say, well, that coconut was mine, I'm moving it away. The law requires, or common law requires, that whatever you brought to the land stays with the land and you can't move it. So, Mr. Sankrantin.
Also, Nana, as you rightly said, if they are movable items, you can move them away. But if they are affixed to the land, you cannot take them away. That's simple. Yes.
So Dorothy Adezoa Chumesi says, insightful. Thanks for the program. Vera Jivamis again is asking, breach of agreement with who? Normally, we are not the first person who has purchased the land in the area. The legal land use may be agriculture, but there may be housing estates and other major developments in the area already. What do you do in this instance? I guess you have to look at your agreement. For a lot of leasehold and a lot of land transactions, forget about what is happening around you. What have you got? Because ultimately, if you put your foot wrong, you might be sued or you might lose your property. So forget if your next door neighbor has agricultural use and he's using it for a hotel. It's his fight. But for you as an individual, make sure that what you have in your lease is what you're using your land for. I think that is the point we are trying to make. Even though others might not be doing it, and even though we don't enforce planning as much as we could have in Ghana generally, you would have to see yourself as an individual who is surviving this rather than thinking of the general area. Mr. Sankranti.
Then I think if I understood her, she's saying that there's a land maybe for agriculture, then you might have a burden on it. Is that what she is trying to say?
Yes. Yeah.
So it differs. For instance, if it's like an agriculture and there's a burden is an ancillary, to the use for which you have actually purchased. That cannot be a problem at all, because that's an ancillary to the use for which you have leased from the lessor. Yes.
I agree. So yes, I guess it depends on the circumstance, but yes, I agree with you. So Chrisley Amprechu says, at renewal, how much is to be paid? Who determines that cost? By negotiations or solely by one party? Well, I guess you have answered the question, Mr. Amprechu, to a large extent. It is by negotiations, unless the lease provides otherwise. The lease, and it's all part of the things that you can negotiate on. The lease can provide for how you actually calculate the rent on renewal. If the lease is silent, then most often than not, both of you would have to sit down at some point in the future, 99 years from now, perhaps not you, your children, and say, well, this is how much we've got. And then a lot of other factors come into this valuation. Are we valuing the land alone, or we're valuing the land with improvement? Because technically, when your lease ends, your building and the land becomes the owner, goes into the ownership of your landlord. And then there's another class of people who are buying estate houses. So they didn't take the blocks, they didn't take the cement or the water. They just went when everything was built for them. So theirs would also be different from that person who bought bare land and built on it. But it depends on your lease, and that is why I guess the advice we're giving here is you must make sure you negotiate these things to suit yourselves. There's nothing like a standard beside that which the law provides or prescribes, which you cannot negotiate for with your landlord in a lease. So we've got Kingsley. Where have I think I have. Okay, so we've got Eric Mante. Is Lawyer Sankranting, at what point should the duration of the lease commence? I didn't get that quite clear. So, Lawyer Sankranting, that is to you.
At what?
At what point should the duration of a lease commence?
At what point should the duration of the lease commence? The commencement of a lease can start in the past, can start in the present, or can even start in the future. So it depends on how that you agreed. So it could be in the past, it could be in the present, or it could be in the future.
Okay. So I have another question from Mr. Amprechum, who is saying, must the lease agreement be deposited in the court registry? Must the lease agreement be deposited in the court registry?
No, it's only, so far as I know, unless you want for custody service, you want custody services, and then you pay for it. But you don't need to leave your lease document in the court. What I know is a will. That a will, yes, but for a lease, unless even the banks provide custody services, so you can contact the banks and then pay for custody service so that your lease will be kept for you.
Okay. Vera is asking, in the event that the coordinates in the schedule does not match the site plan, legally, which of the two sections of the lease take precedence? I think, Mr. Sankranti, you saw this coming.
I think I'll have to look at, because I was looking at this before we started, but we'll get her the feedback. I do want to say something that I am not sure of, so I'll get back to her on that.
I think ordinarily the words actually take precedence. But it's a matter of the agreement, the document you have, and where the errors are. When the matter should go to before a court, they would want to see the intentions, the parties, the positions, the negotiations, and all that, because essentially it's almost like having a lease agreement where there are covenants which have not been perhaps laid out clearly. So you look at all the circumstantial evidence, look at all the how you came by that site plan. Most likely you would get another surveyor to go there and pick the points, and all those things would come into determining which parts actually are taken to be the correct coordinates of the land that you've bought.
Yeah, so Nana, I think what you are saying, it definitely, if there's an error, and for instance, if your land is a unique one, it's in a unique position. So definitely, if the coordinates are wrong, that means that you need a surveyor to go and make sure that the right coordinates are picked to match up with either the site plan, the previous site plan, or and then the schedule, to be sure whether your language is unique, is actually corresponds to which of them. So which one it corresponds becomes your land, and therefore that amendment can be so made.
Okay, so Ejapoma Siama is saying, thank you very much, learning a lot from this session. I think I've answered various questions on the slides. And the next question is from Janet Mante. He says, how do I transfer ownership of the property to my husband? Mr. Koranteng.
So if you want to, so if you want to transfer to your husband to hold it as his own, that means that as the law provides, then you need to make that intention clear on the document. So if the intention is not clear on the document that this property is being transferred to my husband to hold it alone, to be the sole owner, if that is not clearly stated or explicitly stated on the document, then it is joint tenants per the Land Act. But where it is clearly stated, then that presumption has been rebutted.
Okay. So now Ado, my apologies. The WhatsApp number is +233 5,673 +233 5,673. I'll see if I can put it on here, so you can see it there. So that is a question which Na Ado put up. So those who want to send WhatsApp, I have, please do not forget to share. In terms of the slide, we would have a follow-up summary, and that would include the slideshow. So please do subscribe to our channel, and do also follow our Facebook page, and do subscribe on our website with your email address, so we can send you the show summary and the slides as well for you to use for yourselves. And the next question is from Mr. Amprechum. Do you have an option of a leasehold or freehold to choose from? No, I think right from 1992, you had an option of freehold and leasehold. If you were buying family land, it could be freehold. The Land Act 2020 has now included family lands, or put family lands in the same category as two lands. And therefore, at this point, if you will get freehold land, then it must be from an individual. And I think there wouldn't be a lot of those people in the market who are selling freehold land. But yes, that is the current situation. And if you have the option between a freehold and leasehold, obviously, as I've explained, leasehold is a wasting asset. So freehold is what you have to go for. But at this point, it is not the primary interest that you have available in the market. So we have Dinkra is question difference between freehold and leasehold, please. Okay, so freehold essentially is forever. You have it, and yes, you can have some restrictions. You can have a freehold which says you cannot build more than a house of more than maybe 3,000 square feet, or you can have restrictions on freeholds. But freeholds essentially are yours forever, and leaseholds are wasting assets. They would come to an end at some point. So if anybody offers you a leasehold, you must be aware that it is going to come to an end at some point. That essentially is the difference between leasehold and freehold. Na Ado, kindly call out your WhatsApp. Yeah, you are giving that. Alexander Sihine is saying, thanks, guys. Papa Toro is saying, very educating and eye-opener. Mate006 is well done, guys. Very informative. Papa Toro, after issuing a land title, can we go back to the family to negotiate and extend the duration of the lease before it ends? Mr. Sankranting.
I think that there is a window of that where the existing lease is coming to an end. You can then surrender and renew. So you have surrender renewal, where you surrender the unexpired term. Let's say you have 10 years more to go on on a lease. You surrender that 10 years to the lessor and then get a fresh lease of let's say 99 years, and you pay the necessary consideration regarding that.
Okay. So Christabel has given her email address. For Christabel, if you can, please subscribe as well on our website, which is landpropertyfocus.com, so that you will be on our constant mailing list, and we will send you the slides. Now, Juliet Pedersen I think Vera should engage the services of a lawyer. That's all. Okay. Vera, there you are. Juliet is giving you good advice. And Vera again, how do I know that the professional knows what he has to do? Well, Vera, I guess I will build Mr. Sankranting out here. That is why I guess there's something which is missing a little bit in our professional classes, and that is that we don't seem to have professional indemnity insurance. So I see a bit of your point. If a professional doesn't do the work for you, you may not be able to sue them and those things. So sometimes I see the apprehension, but we must also train ourselves to use those who are specialized in these fields to actually do the work for us. If it is possible for you to make the inquiries and actually find answers for yourself, then that's fine. If not, I think what Mr. Sankranti is saying is that we should put our trust in professionals because they know these things, they know the pitfalls, and they would make sure that you get the right answers. Edward Akufu is saying, what is the standard for the number of witnesses needed for an agreement to be valid? Mr. Sankranti.
Standard of the witnesses.
Number of witnesses for an agreement to be valid.
Oh, if they are parties, if they are just a lessor and a lessee, each one needs a witness to witness to the signature. That's it.
Okay, just to make sure that somebody has signed. Jay Kwashi says, this leasehold thing, the more I look, the less I understand it. There are some stool lands that are sold with just a receipt with no accompanying agreement. Which category does a situation like this fall under? So I think, Mr. Kwashi, this is a question that relates to something which Mr. Amprechum had asked previously about receipts for land or the chief giving sheets or allocation papers. This primarily relates to the Ashanti region. And the Ashanti region has a peculiar system of land management which is relatively more advanced than in other parts of the country. And that has actually influenced these things. I think it's built on trust much more than anything. So essentially, when you get a lease or when you get the allocation paper, I guess if you're not a native of the town, you're moving yourself towards a leasehold. And if you're a native of the town, you're moving yourself towards a usufructory interest, which is an interest which kind of renews itself automatically. So it is an interesting point, and it is something I guess the lawyers and the surveyors may have to look at in terms of what pertains to the Ashanti region. But at this point, it's not an issue. So nobody seems to be pushing to get an answer. But I can see that it would, because there's no document, we have to bring in a lot of the laws, a lot of the practices, and a lot of the customs to actually determine what the status of such receipts or such allocation papers are. Mr. Sankranting.
Now, I think you have nailed the question because you come from the Ashanti part of Ashanti region, and therefore you are very conversant with what actually transpires in that region, and so I think what we have said is enough.
Okay, so Edward Akufu says, for conflict resolution purposes, can agreement be considered valid without witnesses? So, Koranteng.
Can agreement be what?
Be valid without witnesses?
No, for witnesses are supposed to witness the signature. So unless I wouldn't say that. But one, I mean, if for alternative dispute resolution, it could pass. But if probably if it goes to court and then the court decides otherwise, that is at the remit of the court. But with the alternative dispute resolution, I don't think it would be much of a problem. It can pass without the witnesses. But if we should go to court, that I cannot speak to that.
Okay, so I guess, and I haven't read up on that, I guess there are some requirements in terms of agreements and its validity and the fact that people must witness the signatures. And I guess sometimes as well, it is also to make sure that somebody else is overseeing what has happened. So, there's somebody there who witnesses the transaction. I guess that's where witnesses come in. But Professor Kufu, I think we'll come back to you substantively on that. Janet Mante is saying, thank you for this wonderful session. Can I have lawyer Osai Koranteng's number? Okay. I guess we will send, if you do send me a WhatsApp message, I would then respond and send you lawyer Koranteng's number. Nana Ado saying, always the barcode on the site plan comes with a different plot size. How do you correct the size on the document? Okay, I think that is more to do with the land surveyors than Mr. Koranteng as a lawyer, even though we are property surveyors. If I do understand you correctly, if the plot size, it should be the same. It shouldn't differ, irrespective of if they go to the site and pick it and say it is 1 acre. That 1 acre must find itself in your agreement. It must find itself in whatever barcoding that is done. So at some point, there should be a correction where you only have one piece of land and one piece of or one standard land size. I tell you why that is important. You may have your site plan saying you've got 1.5 acres, and then you put a barcoding on and it says you've got 1.3 acres. So 0.2 is off. And then you put a 1.3 acres in your agreement. You are essentially not transferring the same piece of land. So it is something that if it's an error that has found itself in the system post barcoding, then it's something that we have to look at. Because essentially, what you're buying has specific dimensions. Those specific dimensions must find themselves in the agreement. Otherwise, you're buying something different, or your lease is talking about something different from what you've actually been given. Eric Mante is saying, thanks for this wonderful education. Vera says, thanks very much for this educative session. And Joyce Edu says, not just to witness signatures, but to witness the contract, unless a will to witness only signature. Okay, all right. So I guess Joyce is adding to the fact that the witnesses the witnesses' signature is not just to witness the signatures. I guess that is more what she's trying to say is that is more in relation to wills, where somebody must witness that you have actually signed, and then that is your will, as opposed to leases where she's saying that the witness is also to witness that agreement has been put in place. The lease itself has been put in place. So thank you very much, Joyce Edu. Juliet Pedersen Ayi, very insightful. Thanks a million for this free education. Let me see if I have any more questions on WhatsApp. Ado, okay, we don't have any more questions. So, everything that is good comes to an end very quickly. I would say a big thank you to lawyer Osai Koranteng for joining us today and for helping us to break down this topic of leasehold, which is very important to Ghanaian land holding. I must also say a big thank you to a gentleman who has made this program what it is. Kwame J of Canmore Media, who has been my partner through thick and thin, and has been helping me with this program. I think I haven't said thank you enough. And today I'll say thank you to him for all the help and support that he's been giving us. So please do make sure that you share our page with your contacts, and be sometime within the week we would send you a snapshot of what we have discussed today together with the slides so that you may use them. Please also do subscribe to our YouTube channel. Our WhatsApp number is now available. If you do have any questions on any of these issues, we are more than happy to answer them. So let's hear from you. Send us an email through our email address, info@landpropertyfocus.com, and we would all together be able to learn, have discussions, and be empowered when it comes to land and property issues in Ghana. Thank you very much for watching.
Thank you.